Hello, everybody. Welcome. Thanks for joining us today. My name is Mike Gibb. I run accountsrecovery.net, and I'm going to be moderating today's webinar on the areas of the debt collection rule that plaintiffs' attorneys will be focusing on. When the debt collection rule goes into effect later this year, fingers crossed, it will upend the types of lawsuits that are filed against collection agencies. Today in this webinar, which is being sponsored by TCN, we have a panel of experts who are here to share their insights into the areas they think plaintiffs' attorneys are likely to focus on. I did want to take a quick second and talk about accountsrecovery.net, which I hope acts as a one-stop shop for all your information and educational needs. I wanted to spotlight a couple of ongoing video series that you'll find available for free on the site. Training Bites is a series featuring insights from Mary Shores, one of the industry's leading communication experts. And You Wanted a Rule, You Got a Rule is a series featuring John Bedard, who is breaking down each section of the CFPB's debt collection rule. You'll find both series in the video section on accountsrecovery.net. As I mentioned, this webinar is being generously sponsored by TCN. You'll get the chance to hear about them a little later in our program. Now, let me tell you a little bit about today's speakers. Lauren Burnett from the firm of Messer Strickler represents attorneys, financial institutions, debt servicers and buyers, mortgage lenders, and more in a broad range of compliance management services, including risk assessment and remediation, due diligence, third-party monitoring and auditing, training assistance, and litigation management and oversight. Lauren's a member of the National Creditors Bar Association, is also active in ACA International. Sean Erdishek is the Chief Compliance Officer and General Counsel at Sequium Asset Solutions. Sequium is a full-service business process outsourcing and collection agency handling both first and third-party recoveries. Sean oversees all aspects of compliance management, client and vendor contracts, regulatory matters, and litigation. He's been awarded the Credit and Collection Compliance Officer and the International Federation of Certified Collection Executives designations from ACA International. Lorraine Lyons is a partner with Malone Frost Martin in Dallas. She has more than 20 years of experience working exclusively in the accounts receivable management industry. Lorraine has represented the industry in lobbying efforts, has served on ACA International's board of directors, is a past president of ACA of Texas, and a past chair of ACA's members attorney program. Patrick Newman is a shareholder in Bassford Remley's Consumer Law Defense Practice Group. He's been involved with the credit collection industry in one form or another since he was 19. Now he represents industry members, helping them prevent and navigate disputes in federal and state trial court. He has extensive experience working closely with in-house counsel and financial services providers, defending the FDCPA, FCRA, TCPA, and other consumer protection claims, including class actions. The format for today's webinar is going to be a discussion among our panelists. We encourage everybody to ask questions, and we'll get to them as the discussion is ongoing. To submit a question, please either send it to us through the Q&A tab on your Zoom webinar control panel or send it to us through the chat module. Since we're going to be talking a lot about compliance today, let me read the following disclaimer. This presentation is not intended to be legal advice and may not be used as legal advice. Legal advice must be tailored to the specific circumstances of each case. Every effort has been made to ensure this information is up to date. It is not intended to be a full and exhaustive explanation of the law in any area and should never be used to replace the advice of your own legal counsel. With that, let me bring on our panel. We can start our conversation today. What I thought would be good as a starting point is to go through maybe some of sort of the bigger areas that are covered in the debt collection rule, and maybe get some insights from you about where you think potential legal landmines or lawsuits are lurking. The first thing I thought we'd talk about today are the call frequency limits, and maybe Lauren, you can kick us off.
Sure. So in days past, there's always been sort of this slippery concept of how much is too much, how much is enough to constitute harassment, how often can I contact you, and what are the limits? And for those of us that do defense work, those can be sticky to grapple with because they raise a lot of factual issues that are best left for a jury rather than giving them to a judge to decide as a matter of law. So, on the one hand, I find that the call frequency limits are encouraging in that they do give some hard and fast numbers that people can abide by and program around. Where I think that there lies some potential for really, I think just kinks to work out in the beginning of the implementation process is that the communication limitations aren't limited to just calls. They're looked at in the context of communications as a whole. And so it would be one thing if this were a true call frequency limit, and you could implement some kind of a lockout protocol so that it's literally impossible to place a call if you're within the limitations period. But here, you're going to have to look at the full panoply of your communications together, not just calls, but also emails, also letters. And as the technology continues to improve and evolve, and as debt collectors embrace these evolved methods of communicating with people, you're going to be looking at things like chat too. And it's going to push the limits of what is and isn't a communication, which is, you know, still sometimes in flux, even 40 couple years after the FDCPA's enactment. And there's going to be a lot of ambiguity in there where I think we're going to see test cases.
I think that's well stated, Lauren, and I agree with that. And one thing I also defend these cases, and the thing that caught my eye about the frequency limitation is that it's a rebuttable presumption, and that should immediately, that language should put up your antennae, right? For that's legal talk there. And so yes, we've got this idea that you are presumed either to be in compliance or not with the relevant FDCPA section if you stick with these limits or don't, or go outside of them. But the idea is we could make a factual showing, right? Either on the plaintiff side or the defendant side, that there was still an intent to harass or annoy or not, right? So to your point, Lauren, right? That's a quintessential jury issue. So yes, we've put up some guardrails around what these claims might look like. But as you know, the world of FDCPA law develops at the margins, right? And so I think we will see some litigation on that, akin to the safe harbors, right? Everybody knows about the Seventh Circuit. For a time, they were really fond of creating these safe harbors, which I think was very well intentioned, as in, here, this is how you might go and do this thing that we keep seeing and we don't want to see anymore. But as I think we've all experienced, it didn't shut down the litigation. That wasn't really the end. It was kind of a new construct. It was a new way of arguing about it. And so I expect that we're looking at a similar thing, right, with the frequency limitation, which is, this is a well-intentioned thing to give some certainty and reduce litigation. And time will tell if I'm right or wrong, but I think it just shifts our focus, right, a little bit. The schematic looks a little different.
Yeah, I agree with that completely. And although this looks like a bright line rule for the industry, there is some subjectivity built in there. For example, there's an exception for providing a response based on a consumer's request. And so I think we'll see gray areas around that exception. And also the call limit pertains to each particular debt. So I'm sure we're going to see situations where an agency has multiple debts from the same consumer, yet when the consumer receives a certain level of calls, that they'll file litigation without realizing that there's multiple debt, or trying to assert that all the calls were related to one of the accounts.
All very good points. I agree with all my co-panelists here, and just want to back up a little bit and thank everyone for allowing us to participate, and thank you to Mike and to our sponsor. One thing I want to also add is an area that I think we need to take a look at is making sure that if we have that provision for the exclusion, that if we have the consent of the call party, we can make additional communications, but we got to be real careful with that. Make sure that we've got really good training on what is consent. It's not like a yep or a yay, or make sure it's a solid consent, and make sure that we are revising our procedures and our policies to what is consent. We train that. And then of course, don't forget, I love that we have some guidance here, but we got to remember our state law rules too, that we got to comply with those laws that are more restrictive.
Speaking of state law and other things to consider, we have a question that came in that said the FTC states that 3 calls per 30 days makes everything very convoluted. Does anybody have any thoughts on this and the CFPB rules? Do they overlap? Nobody wants to jump in and say it depends yet?
It depends. Goodbye.
We could come back to that. That's fine. So moving on, we've talked about the call frequency limits. Let's move on. I'm sure we can spend hours talking about what I want to talk about next, but we'll try and limit it to a little bit of time, and that's the model validation notice. Obviously, there's still a lot for agencies to kind of wrap their heads around about the information that needs to be included in the model validation notice, how to include it, things like that. But just wondering, sort of off the top, if there are any real issues that you see as what plaintiffs' attorneys might spotlight or focus on as this rule gets rolled out. Maybe Patrick, you can start us off this time.
Just stop nodding my head. I keep getting in the groove, and I get picked on. I get picked on. Yeah, this is more of an observation, right? So before we had a model validation notice, there were still some pretty well established rules of the road, if you like, for what you would do with your initial communication. And notwithstanding that, we had kind of a form or things you'd expect to see. And that still was getting manipulated after all of these years and all of the case law in ways that, you know, if somebody looked at it with experience from a legal perspective might say, yeah, maybe don't do that. Like we still, even to this day, I think we see cases about misstating the G notice, right? It's like, it's the most well-known concept to everybody in the industry who's dealt with letters, and still it gets goofed up. So I guess my point is that, again, we have maybe this new construct to work off of, maybe some more consistency, but there are still variables that you could input into this letter. And so long as that is the case, there will be some fertile ground for lawsuits. And this is applicable to all sort of initial notices. I think part of it is a philosophical approach. Do you view the initial notice as I'm checking off a box, a compliance box, or am I trying to generate revenue, right? And when you get into the I'm trying to generate revenue box, people get creative. And I've said this in a prior webinar, but I'm going to use it again because I like the line. Stephen King's book on writing, he will talk about how he'll write and then he'll put it away in a desk drawer, the draft, and he'll take it out a day later. And he goes through and he finds the lines in there that he really likes. He calls them his babies, and his advice is kill your babies. The more that you like it, strike it, get rid of it, take it out, right? And that's my advice generally on the initial notice, right? Is if you've got that line in there where you're thinking that's gonna generate cash, get rid of it, take it out, just don't do it. And so that, I think that possibility still exists, notwithstanding the fact that we have a model G notice, and I expect that people will continue to push some of those limitations. So I don't think it eliminates litigation, but it's a great starting point. I love the idea of it, and that maybe it can bring us more to consensus.
Patrick wins the webinar for the Stephen King reference. Seriously.
It's recycled, half points, it's recycled.
One thing that I think is really important that everybody keep in mind is that the proposed model validation notice is a model. It is not a safe harbor. And those are two different things. And I've said that in the past, but I'm going to say it again, because if you really want to nerd out on this, and you compare the model validation notice with some of the things that some of the courts have said about validation notices in a variety of cases from all over the place, they don't line up exactly. And so again, we're going to be testing the margins here to see what needs to be in the G notice, what can we hold over from, Patrick makes a good point. There's very well-established language that we include, and we're good, and we're giving them that validation notice, and then we wait out the validation period, and then we focus on the language designed to start getting people to pay. But where are these two, the language we've been using forever, and now this proposed model, where are they going to mesh together and line up? And it's going to be through litigation and testing that we determine those boundaries. But I think that just deciding that this model is it and adopting it wholesale, thinking that you're going to have a safe harbor, it's not a safe harbor. It's just a proposed model. So it may or may not hit all the notes that you may still need to hit, depending on where you're sending it.
Yeah, Lauren, I agree with that. And I think enterprising consumer attorneys are going to be apt to file suit whenever they see any material deviation from that model form. And I think there are a couple of aspects of it that could be a little tricky, one of which is the itemization. There are a few different dates that you can choose among for how you itemize the debt. And I think that leaves some area where there might be inconsistencies and discrepancies where people can be tripped up.
Yeah, I agree. And I think one thing we all need to keep in mind, it is a model notice. It's not a payment request letter. And I think that's where we got to, think differently about this. That's why you don't see a lot of payment options in that model notice. It is a notice. It does have the required fields. I think that you've got to make sure you're if you're going to use the model notice, track all those required fields, make sure it's in your letter. Because if you deviate from it, like Sean has said, you've got to make sure it's, in a substantially similar form in order for it to have that same, potential safe harbor applied to it. I think the itemization is tricky because it depends on your business line, which date you're going to pick. And we all don't collect the same types of debts. And within one agency, they may collect several different types of debts. And it's not necessarily a transaction date, might not apply to another business line. It might be last payment date. So you're gonna have to look at those 5 potential itemization date options that you can put in there. I think that's an area you've got to be careful with. And that it's consistent, that you use it. Another one is calculating the reply date. I think there might be litigation over that. Did someone actually, have sufficient time? We have guidance, but that's not the all end. We have to make sure, the validation period runs 30 days right after the consumer receives it. And honestly, we don't have that crystal ball knowing when they actually receive it. There's some presumptions, but I think that there's going to be some dynamics that come into play. We got to account for the weekends, we got to account for legal holidays. We know that. But what about a severe ice storm that happens and delays the mail for a week? We won't know that the day we drop our letters in the mail. So there's some things that we have to consider that I think that can trip us up. And so we are going to build as much time as we think is reasonable. I think of those dates as what the approach is from the folks I've talked to. And that's about as best we can do on that provision. But there's so many elements within the model notice that you've got to look at on the required fields just to make sure you get it right. And I think all that is subject to potential litigation.
Lorraine, you bring up something that came up in a conversation I had with another attorney who had a client who had a claim against one of mine. And it was about exactly that, receipt of the validation notice. And he had a potential overshadowing claim. And we were talking about the validation notice, and he said, we all know that USPS is a mess right now. And the letter, was dated sometime in November, but not received by the consumer for 65 days after that. I'm still getting Christmas cards at my house. It's February, but I'm getting Christmas cards that are in fact, postmarked in December. So one thing that I noticed, as I was reading through the rule, and in particular reading a lot of different breakdowns of the rule, is we're beginning to see injection of reasonableness standards into things. And there's an expectation that that on both sides of the consumer debt collector relationship, that there's to be a modicum of reasonableness and common sense, right? And so how is that going to translate into our practices when we're implementing some of these, when we all know that USPS is a disaster right now? Do we start collecting on day 31 after that validation notice goes out? Or do we maintain the flexibility to build in, maybe not a permanent buffer, but some kind of a buffer to account for things? And taking that down the road a little bit further, if we get sued over something like that, how does that knowledge, in light of this reference to reasonableness in certain spots in this rule, how does that start to factor in? Because for the longest time, the refrain has been the FDCPA is a strict liability statute, and issues of reasonableness and knowledge and intent don't always play in unless we're talking about the section of the statute that is not strict liability, but that's a whole different rant by me. So, but that, things like that are starting to show up in real time, and the rule isn't even implemented yet. So it'll be interesting to see how some of that begins to eke its way into the case law that's going to follow.
It's a good point, Lauren. And I just wanted to circle back on something I think Sean highlighted, and I'd be curious to hear, particularly from our in-house folks, but Lauren too, I know you're in the defense world, the itemization date, right? And you're picking your one of your 5. Do you all see any particular vulnerabilities in the world of medical debt? Because I know in other contexts, pinning down date of delinquency and all that good stuff has been a challenge, right? Independent of now the rule. So I was just wondering if you guys thought that might be a particular area where we'd see more litigation.
I mean, I think on medical debt, it depends on the provider that you're working for. I mean, some of them may give you less payment dates, which the rule does speak to. You can apply third-party payments, which is nice, like say from an insurance company that may have paid on the debt. But I think what's problematic with the medical debt is, as we know, when someone gets medical treatment, especially at a hospital, they're going to have several different lines of charges. And to itemize all that is a little challenging. And I know the rule says you can put it on a separate page, but then again, the separate page isn't subject to the safe harbor. So it's tough. That one's a tough one. Medical is tough. You're going to have to really go back to your clients to see what they can provide that will fit in one of those 5 elements that can be an itemization date. And again, it's going to be based on client. And then, so for example, if I'm just an agency that just collects medical, I might have different itemization date for client A, B, and C because of what they provide in their in the files that come to us.
Yep, absolutely. It can vary completely by the type of debt that you're attempting to collect. So I think you need to make sure that you receive that itemization date that is perhaps going to be most appropriate, because not all of those dates or fields will be available for certain types of accounts.
Excellent. Well, I just want to jump in for a minute. I'm going to hit the pause button on our discussion, and I'd like to invite McKay Bird from TCN, the sponsor of today's webinar, to say a few words. McKay?
Thanks, Mike, and as well as to the other participants, everybody that has made this discussion possible. As Mike mentioned, my name is McKay Bird. I am the marketing director here at TCN, and as many of you might know, is that TCN is a cost-effective call center platform. And what we do is we power traditional call centers, collection agencies, and as well as we have thousands of other call centers around the world that use our software daily. TCN has continually stayed current with the TCPA and as well as the CFPB by introducing features to our core platform that make it easier for compliance in particular, one of which is TCN's compliance suite, which has built-in natural language processing, which helps you build your rules naturally just in your own language. So for example, if you were looking at building a rule for denying outbound calls, you would simply type deny outbound calls, and you would then could specify whether that's in a time period or specific region or any other type of criteria that you would want to target against. And again, that's based on compliance rules and those things that we're talking about today. Something interesting that a lot of our clients have started implementing with the new Reg F rules coming out is limiting calls, 7 calls in 7 days by an account. And that is something that we can accomplish with some of our compliance tools, and that we see very beneficial. Also built into our platform, we provide built-in data management services that eliminate data entry errors, BI with reporting dashboards, so you can get down to the minute metrics on collections and as well as agents that are working the floor or at home now, and as well as call recording with storage and redaction and voice analytics. There's so much more built into our platform, but regardless of size, location, or even the application, we can provide a robust call center solution for your call center. And I would invite you guys to visit tcn.com to learn more and to get more information. Thanks, Mike, and thanks everyone.
Thank you, McKay, and thanks again to TCN for sponsoring today's webinar. As he mentioned, that the website is tcn.com. I put a link there in the chat box for anybody who wanted to click on it and check it out. We did have a couple questions that came in on the model validation notice. One of them was asking about not having the model validation notice, not having any statements or disclosures about ongoing interest and charges. So the question was, do you anticipate that consumer attorneys will be filing suits based on the lack of a Miller type statement about ongoing interest and other charges?
Yes.
Succinct. I
Yes.
like it.
Yes, I mean, I absolutely, there is too much case law out there. And there are so many different factual permutations of the interest and costs and fees related issues that there's no way that line of litigation is just going to choke off. No way. So it's going to be another place where, you know, how are courts going to fall on this? You add a line, you add, you know, the McCalla or a partial McCalla disclaimer to your letter, thinking you're giving the consumer more information. You want them to have the information that they need in order to make a decision about what they're going to do with this account. You know, is there conflict between the itemization box and your Miller disclaimer? Is the letter capable of two meanings, one of which is inaccurate? You know, there are a lot of different ways that I can see litigation coming down the pipe on that, but unequivocally, yes, we're going to continue to see those cases even after folks start using the proposed model notice.
And the question will be on that is, do we get to the merits of those claims? Because the plaintiff's bar is having a heck of a time pleading those cases in a way that satisfies Article 3, right? We may actually start getting answers from the state courts, right? In Wisconsin, Indiana, and Illinois.
Yeah.
Really interesting, because it'll be sort of a brand new take, right? From a group of courts and judges that just are not familiar with the 25 years worth of the Miller-McCalla stuff. So a new frontier. That's
so important. I'm gonna repeat what you just said. Lack of Article 3 standing does not mean the death of the case. You know, most states have saving statutes. A lot of states have a lot of case law on what happens when something is timely filed in federal court and then dismissed for lack of Article 3 standing. I don't want anybody to labor under the assumption that winning a standing argument means that the case is over. It may just mean that you are back where that case started and now you have to contend with a state court judge. So that's so, especially with all of the Seventh Circuit standing cases coming out, I hate to be the one to, like, you know, mute the good news, but you have to keep that in mind, especially in this circumstance where you're absolutely right. This is going to be new frontier. And you know, judges, federal and state, are going to be looking at issues that they've never had to grapple with before. So just another brick in your strategic decision-making process.
Absolutely. And then we're going to get more patchwork of laws.
Yep.
Yeah. And that's unfortunate, because I really thought that this was a great step by the CFPB to publish this rule, you know, after all the years they spent working on it, and, you know, hoping that we would get some good, you know, clarity. But yeah, it seems like there's been some strategic plans to kind of find a work around this by just bringing the claims now into state court.
Another question that was asked about the model validation notice, but I think it applies to everything we're talking about with regards to the rule, is that, do you think that consumer attorneys will be suing collectors for A, using the model form before November 30th when the rule goes into effect, and B, not using the model form after November 30th? You know, with respect, I'm sure the answer is probably going to be yes again, Lauren. I'll steal your thunder. But with respect to either the model validation notice or any of the other provisions of the rule, maybe is there any insight or advice that you can provide about how to sort of manage that dynamic?
Yeah.
Go ahead, Sean.
Sean,
I
please.
think consumer attorneys are certainly going to test, the bounds of this and pursue cases on both sides of the line. From my perspective, I'm looking to target the effective date in terms of implementing all of our changes, especially when it's going to be something like the model demand validation letter. Just knowing that consumer attorneys are going to pay heightened regard to that because it's something that's new and hasn't been in effect or used previously.
Yeah, I agree. And I think that sounds like a wise protocol to be putting into place. And we've seen a bit of this already, right, with the notice of proposed rulemaking. And that's been persuasive authority in some cases, right? Even if it's not getting cited by judges, judges are people and are susceptible to reasoning that they agree with. And so I could see a plaintiff's lawyer pointing to what the rule is going to be and why a current practice is problematic. And certainly I think Sean or maybe Lorraine already touched on this earlier, that is, if there's any material deviation from the model letter, it's going to put up red flags and it's going to invite litigation. So the second part of that question is a wholehearted yes, absolutely.
And in terms of how to manage those, I don't think that any type of a litigation management strategy is going to be any different from the factors that you have to consider now. What's the nature of the lawsuit that you're dealing with? Is it a one-off type thing, or does this go to something fundamental and operational, something that you don't feel like you can change? I don't think there's any aspect of these rules that's going to be off limits for litigation. I think that, I give consumers and their attorneys a lot of credit for thinking as far outside the box as they can and articulating these causes of action and being able to do so in a way that can make it challenging to get rid of some of these lawsuits on a motion to dismiss. And we've all seen first or second hand how a motion to dismiss can cause problems down the road when it's denied by spinning off copycat litigation. So, what to do with these lawsuits when they come in. I know I joke and I say the lawyer answer is always, it depends, but it really does depend. What is the focal point of the lawsuit that you're receiving? Validation notices are fundamental. Those are things that you send on a big scale and they can be difficult to change because, the statute says what it says. And now this rule says what it says. So you're just going to have to look at the role that the conduct giving rise to the litigation plays in your operations and, look at the long-term ramifications of settlement versus defense. But we do that with every lawsuit all the time already. This is just going to add, a whole new layer of a whole bunch of new theories over top of it.
Yeah, and I think what I want to add is that we're all going to be facing change here. And as we make changes, that's what makes us a little vulnerable to claims. And so we know that the model notice itself, we use the model notice as one option, right? And we know that satisfies the validation notice requirements and the clear and conspicuous requirement. I want to make sure everybody hears that one. There's also the requirement of clear and conspicuous. So if you decide not to use the model notice, you want to use something substantially similar, you got to make sure that what's in your letter is still clear and conspicuous as it relates to that validation notice. And that kind of brings up the question of, boy, we've all for years been tracking the statute as is to put in as our validation notice. And the courts have been okay with that. We've had early litigation on like a word that says a or that or whatever the, or, we've had those kind of, arguments. But at the end of the day, we've all been doing pretty much the same thing with respect to the validation notice. So going forward with this new rule, we got to remember whatever we choose, whatever path we go down, the information needs to be clear and conspicuous in that validation notice. And I think that itself lends to litigation. Is it clear and conspicuous if you deviate from the model notice?
Well, that's a term that ultimately a judge is going to have to define for the industry, isn't it? Clear and conspicuous, and the other sort of subjective terms that are in the rule.
I think that depends too, because, generally speaking, a lot of judges like to say that questions of reasonableness are factual issues for the jury. There are some judges who will pull the trigger on reasonableness and harassment and some of the other, factually driven claims. For the most part, there's good circuit level case law out there that says, whether or not something overshadows the validation notice is a judicial determination. I don't know if that's going to hold universally true. I could see judges deciding that whether something is clear and conspicuous is a jury question. And there are a whole bunch of reasons why those judicial determinations get made in terms of, the end goal of that lawsuit. But I think that can be up in the air as well, unfortunately.
Another question, the rule gives required information and optional information. If information listed is not required or optional, can you still include it on the validation notice under the proposed rules? For example, information about a payment portal.
I think it goes back to, you got to decide what you want to do. Do you want to use the model notice? Follow what the model notice provides. It's very specific. Required information, optional information is provided. If you want to go beyond that, then you realize you're not using the model notice. You don't have the potential safe harbor. So, but your information needs to be clear and conspicuous, and you could still be challenged with some type of overshadowing claim. You just have to really take a hard look at your letter to see, is that going to pass, or will that be subject to litigation? I think if you don't follow the model notice, we probably could say, yes, it's probably good. Okay, you probably will be subject to litigation if you don't follow the model notice, because the consumer bar, in my opinion, is going to expect us to use the model notice.
The model notice is geared toward collection agencies more than collection law firms. The notice is not really structured to meet some of the requirements that have developed from attorney meaningful involvement litigation. How do you anticipate litigation to develop around this notice and meaningful attorney involvement?
That's a really interesting question and a good one. We still see a lot of litigation over meaningful attorney involvement where the validation notice does not contain the Greco disclaimer, making it clear that no attorney in an attorney capacity has looked at the particular circumstances of the account. What we're getting are sort of the reverse claims where there is no disclaimer of attorney involvement because an attorney has reviewed meaningfully the accounts at issue, and the consumers are presuming that that type of review has not occurred. I don't think anything about the model notice is going to change that. And so the question becomes whether or not to add something to your letter. When it comes to the validation notice, to build off something that Lorraine said, anytime you include something that isn't required to be in the validation notice, you automatically increase your overshadowing risk. And so, that's true for debt collection law firms, just like it is for agencies. And I think there's no doubt that there's going to be litigation over that point.
I was just going to add in very briefly that I highly suspect that consumer attorneys are going to actually sit there with copies of letters and compare it to the model validation notice. And they're going to highlight any deviation there and decide if they want to bring a claim subject to that language.
I would just, I would add that use the hypothetical of the Greco notice, right? I think you have two litigation issues. One, by adding that sentence, are you still substantially similar in form to the model validation notice? That's one argument. How much mileage you get out of that is going to depend on your fact finder. But the other, right, if I'm right, the optional content includes other disclosures required by applicable law. That is broad. That doesn't say that it needs to be statutory in terms of a requirement. So you might say, pick your, I'm going to get it wrong. Is it the Second Circuit that created Greco, I think? And if you're there, is that a binding requirement? So therefore it's an optional thing that I can add? Maybe. That's probably part of my defense, right? If I have that case. And you're going to see litigation on that, right? You're going to have to. because those law firms they have to put it in there, or they're going to see the claims that Lauren was describing.
That's a great point, Patrick. And I think, we do the same. We look at what's optional and we extrapolate it to the best we can to say that's how we support our positions. That if we could say, and that's a great example that we could say that's a disclosure under applicable law. Same thing with the Miller-McCollum. Disclosure under applicable law.
Moving on, Sean, I know you wanted to talk about credit reporting and how some of the potential legal issues surrounding that as it pertains to the rule. Why don't you share your thoughts?
Yeah, I thought it was very intriguing that the Bureau put that in the second part of the rule. It was something that I've kind of been expecting to see as regulators really start to focus on the issue of deck parking. And so under the new rule, there's a requirement that you communicate with the consumer prior to furnishing information to a credit reporting agency. And that could be speaking to the consumer on the phone or sending them a letter in the mail or an email. But there's also a requirement that you monitor any undeliverable notices that may occur for those letters or those emails for a reasonable period of time. And I think the commentary to the rule states that a 14-day period is what's reasonable. And so I think this is an area that consumer attorneys are really going to target. And I know because I just saw one this week for the first time where they're alleging that we engaged in impermissible deck parking. And that's simply not the case. We sent out an initial validation notice, made telephone call attempts, but because the consumer may not be familiar with that or may not have directly communicated with us, they may think that that type of behavior is occurring when it's in fact not. And enterprising consumer attorneys are already bringing those types of claims.
Yeah, that's a great point, Sean, because there's so many different methods that we can communicate with, whether it be email, text, regular mail. And I think, the undeliverable piece is something we're going to have to pay attention to, whether, we're in the respect like providing the validation notice prior to credit reporting, or, say we want to take advantage of providing the validation notice as our initial communication via email, having to make sure that we monitor for undeliverables. And then at the same token, making sure that the consumer doesn't come back to us and say, look, everything's okay except for whatever, no mail, only want email. And you got to make sure that you document that right and follow that. So, so that whole piece about undeliverable kind of opens up the door to a lot of areas of where we have to watch for undeliverables, undeliverable in emails and texts, and of course in regular mail.
Lorraine, do you think that fits in already with what some agencies are doing in terms of auditing? Like that's a thing that comes up a lot, maybe in the context of bona fide error, right? It's like you've got policies and procedures, but are you actually going back and field testing them every now and again? Do you think there's a seamless transition for agencies on that, or is this going to be more onerous maybe than the things they're already doing?
Well, I know a lot of agencies do monitor for that as it is now, but I think as you open up the communication doors, because not everyone is using all methods of communication right now. So as you're opening up those doors, you got to remember, we got to monitor those channels as well. So right now you may only be doing email and regular mail, but you're not doing text. And so you've got to make sure when we open up that door of communication, we also follow any undeliverables, monitor, for delivery, et cetera. Yeah.
My only additional thought on everything that's already been said, which I agree with, is I don't have a good sense for what segment of the collection agency population is not giving, is not using the initial notice as its first communication, right? Who would actually initiate a call first, and then the 5 days later, or within the 5 days, would send out the notice. Maybe that's happening. But it seems to me this new requirement to precede credit reporting would basically tell you that's just not the best way to go anymore, right? Because I think you knock out this requirement if you send the G notice, right? I think if I read the rule correctly. So it's just yet another reason that lead with the letter, right? And don't lead necessarily with the call. Though maybe you guys have a nuance that I'm not thinking about.
I mean, occasionally you'll get a consumer who has called the original creditor or a prior agency to try to address it, has then learned that it's been placed elsewhere, gets the contact information and makes a call, and the validation notice has yet to go out. It doesn't happen all the time, but you know, every once in a while you'll see that too.
Mhm. I think I would like to bring up another area of vulnerability, and that's using the limited content message and your business name. You know, I wish we would have gotten a little bit more guidance from the CFPB on what is an appropriate name. It would have been nice to have, like, this is a nice wish, like presumption of compliance if I use certain names. That would have been nice, but I know that's hard. But then it's also hard for us because I can see every single name being challenged, like whatever it might be, how like innocuous that name might be. I can see that being challenged, honestly.
It's an interesting conversation. It's actually, I think, a webinar I'm doing later this month on sort of how to rename your business or manage that sort of DBA. Does anybody else have any insights or advice on what agencies should be doing if they opt to use? Maybe is this a reason to not use the limited content message just because you don't want to sort of fall into that potential issue?
Yeah, I think that's always, perhaps the simplest course of action. But I think a lot of agencies are really looking forward to this as another tool in their arsenal. And it really falls under the larger umbrella of third-party communications. And I think that's an area that at least I'm expecting to see an additional increase in litigation over. The Bureau has, in promulgating the rule, has established certain safe harbors for which you're not committing a third-party disclosure violation, one of which being the limited contact message. But they also detailed procedures for email communications with consumers that include the passing of authorization that can serve as a safe harbor. So I really think that all of these different things that fall under the third-party communication umbrella are areas that are going to be targeted.
There was a consent order that came out a couple of years ago, and the name of it is escaping me, so I apologize for going on a little bit of a wild goose chase, but it involved an agency, and the language of the consent order contained what that order considered to be a safe limited content voicemail message, and it was very similar to this. And I remember thinking that's great. We finally have a little bit of guidance, and we have a starting point from where we can sort of start to get over the Zortman versus Foti argument when it comes to leaving voicemails. And then I had a case where the agency used that limited content voicemail. It was a different agency. It wasn't the agency who was a party to the consent order. And it was a third-party disclosure claim. And during the course of investigating the case, we got the call recordings, and the consumer's voicemail said, "You have reached the voicemail of 8675309. Please leave a message." And it was just the mechanical voice. And the complaint said that it was a phone that was used by the consumer's boyfriend, not a spouse, not anybody else, but the consumer's boyfriend. And it yielded the question of, how do we know that we're leaving a voicemail for the consumer? Because that similar language is sort of embedded in this limited content section of the rule too. It talks about leaving a voicemail for the debtor. But when you've reached 8675309, where are the boundaries of being confident enough that you are leaving a voicemail for the debtor and for nobody else? This does a good job of addressing some of that risk, but I don't think that it mitigates all that risk away. And there are lots of different ways that, leaving a voicemail period can backfire even when you're using limited content language. And we know that because it's already happened after that consent order. I'm going to have to look up the name. I'll send it to Mike. I apologize.
Okay. Lorraine, here's a question that popped into my head, and actually somebody what came out and asked it too, is what if an agency opts to not use email communications, but a consumer requests only to be communicated via email, which is against their policy?
Well, I think that goes back to a reasonableness here on each party's end. I don't think the Bureau is requiring us to open up channels of communications that we don't currently have. It's an option. And so, the options in that situation would be, regular mail, phone call, I suspect, or whatever options that agency has available. I don't think there is a requirement. I do not read that in the rule that you have to have these channels, but if you use these channels, it's addressed.
Yeah, I completely agree with that. And to me, then this sounds like a cease and desist from communication request, because you can accommodate the request to send an email, and they don't want to receive communications by any other method. So at that point, you really need to cease communicating.
I had that same thought, Sean, and that doesn't box you in from giving your required notices down the line to the exception, right? Which just says, if we're going to take a specific action, I'm able to tell the consumer that. So it would be a very, very odd and I think unique situation where you were boxed into having to email somebody. And I think I agree with Lorraine. I don't see it under the current rule language.
And that, I'm sure that Patrick uses this argument too. One of my favorite arguments to make is interpreting the rule or the statute or the case in the manner advocated by the consumer would lead to an absurd result. Courts can't interpret this rule in such a way as to yield an absurd result. If the consumer says, I only want you to communicate with me by carrier pigeon, and this rule says I'm able to opt out of all of these things, that's an extreme example, but what the rule was not intended to be was the type of framework to set up just that scenario where the consumer can effectively cease by saying, I only want you to communicate with me using some means that the agency doesn't use.
Going back to what we were talking about with the name, we have a question that came in. I think, if I'm understanding this right, you're communicating with a consumer before the rule goes into effect. The rule goes into effect, you change your name or start using a DBA so you can leave a limited content message. Now you're communicating with a consumer with a different name. Is there any, I guess the question was, how does a consumer make the connection to the name change? Or B, I guess within the context of the conversation we're having now, is that a potential legal issue for a collection agency?
I think I took a wrong turn in Albuquerque. I don't think I followed that one.
Let's say you're communicating with somebody before the rule goes into effect and your name is ABC Collection Agency. But you start using, when the rule goes into effect, you start using a DBA so that you can leave a limited content message. And now you're communicating with the consumer using a different name. How do you sort of reconcile that?
Yeah, I think you'll certainly see claims there from consumers that don't recognize the new name and they don't believe that they've received an initial validation notice about the debt that you're attempting to collect because they don't realize that you were previously operating under a different name. So there's certainly some risk there.
Do you think that could be mitigated by sending an informational letter to the consumers before you start using that limited content message to alert them to the fact that you're going to start using that DBA?
Yeah, I definitely think so. I think then the consumer is on notice about your efforts to collect the debt. They are aware of the name under which you're attempting to collect. And then when they receive that limited content message, that name will be tied to that particular collection effort and debt.
Won't stop anybody from suing. I'm just trying to think of a workaround.
You're basically going through a process of rebranding, right? So, and then that would include probably your website as well with the new DBA.
And I'm getting tickles in the deepest recesses of my brain about some FTC staff commentary from years and years ago about commonly used acronyms and things of that nature that you're actually using in your business, right? So assuming you've gone through the process of obtaining new licensure and like Lorraine said, it's actually reflected on your website and you communicate with your clients that way and that kind of thing. I mean, we all know that if you get sued, you've lost, right? Just out of the gate, nobody wants to get sued. But to me, I have some answers to that riddle from a defense perspective, I think, if you saw that type of claim. I don't think that's a born loser by any stretch.
One last question. Is there any issue with showing a caller ID that is a valid, calls back to us, but is not publicly published? The main phone number is frequently flagged as spam.
I would just, this is maybe not, this might be deflection. This could be the most lawyerly answer yet, but I seem to recall in the Zortman case, which was here local in Minnesota, right, which gave birth to the Zortman message, there was a discussion by the court of the reality that a consumer can hop on the internet, right, to find out who the caller is. And that sort of colors the interpretation of, has someone been deceived, right, or been prevented from determining the caller? Now, I don't like though the lack of upfrontness there, right? Because it just gives ground to bring the suit, right? It produces ammunition potentially for the other side. But again, I think there's at least some understanding in the judiciary that people are still capable, even the unsophisticated or least sophisticated consumer are capable of doing a little due diligence on that. So I don't know if that actually answers the question, but there you have it.
I'm going to dedicate the last couple of minutes to a question that's been racking my brain since I first read it on Friday, and that is what acting director UGO means when he said that they're going to preserve the status quo as it pertains to the debt collection rule. We have a question that came in asking what does that mean? Are we going to see changes? Are we not? Would love to hear any insights that the four of you have on this, because like I said, I really have no idea what he meant when he wrote that. Does preserving the status quo mean the rule's out, we're going to keep the rules out? Or does preserving the status quo mean the rule isn't in effect yet, we're not going to make it go into effect? To me, I hear both of those and I say yes. So,
I have no idea. I saw a headline somewhere and don't remember. I'm awful today with my memory, but don't know the name of the publication, but something to that effect. Someone mulling the delay of implementation of the rules. I haven't seen anything official or anything that I would stand on to say, hey, this may not happen. But I don't know what aspect of debt collection will have the status quo maintained. My guess is as good as anyone else's.
I think it's a Rorschach.
Yeah, I think that's
your answer tells, it tells more about you than actually what he meant.
So I'm indecisive. Thanks. Appreciate that. Go ahead, Sean.
Yeah, I think we don't know is the direct answer on that. The rule is not scheduled to go into effect for, I think it's 9.5 months. So any pause to preserve the status quo is likely going to no longer be in effect once we come to the effect. So the real question is, what are they going to do in the interim? And I don't think any of us can say at this point, but there are certainly options on the table for them. But today, I think we can do nothing but prepare for the implementation of the rule as it exists and as it's been published today.
Absolutely agree. We have no clue what it means, and just prepare. Be ready to pull whatever trigger you want to go. You want to do model letter, be ready to do that come November 30th.
Excellent. Good advice. Well, Sean, Lorraine, Lauren, Patrick, thank you so much for your time and your insights today. Really appreciate you answering these questions and talking a little bit more about the debt collection rule. Thank you very much.
Thank you for having us.
All right. Thanks again to everybody who watched and asked questions today. Thanks one last time to TCN for sponsoring the webinar. Please go to www.tcn.com to learn more about the company. Stay tuned. We've got more webinars coming up tomorrow and Friday and all next week. You can find registration links on accountsrecovery.net on the events calendar. Hope to see you back soon. Until then, take care, stay safe. We'll talk to everybody soon.